All right, good deal. All right, what we're going to talk about today is the use of force in Kentucky. This is somewhat of a modified one because obviously sometimes I'm teaching to law enforcement officers and there are a couple little things that are separate for them that would be different than what the general citizen would deal with. As we go along, I'm gonna give the usual caveat. I'm a lawyer. Every situation's different. You cannot generalize uses of force. When you're looking at a use of force situation, you could have 30 people involved in exactly the same incident. Everybody's going to see different things. Everybody's going to react to different things and respond in a different manner. What I'm going to try to do is to get you prepared that if you do have to use force, and I'm going to say something real definitive right now, force is not a bad word. Force is just a tool that you use to protect yourself or protect someone else, or in some cases to protect your canine. So don't think of force as a negative word. It's a neutral word. We're going to start off, we're going to talk about what's called physical force and deadly physical force. And I'll differentiate between those as we go along. Starting off, we got this thing called the Constitution of Kentucky. A lot of times we talk a lot about the U.S. Constitution, but we do have a Constitution of Kentucky that dates from 1891. It has been modified through the years, but quite honestly, it's probably 95% the same as it was in 1891. You're going to see a lot of language. It's going to look familiar to you. It heavily mirrors the U.S. Constitution. Specific for this, we do have the right to bear arms in Kentucky, and we do have the power. The General Assembly has the power to prevent persons from carrying concealed weapons. Obviously, we've had in relatively recent years changes in the law that have allowed individuals to carry concealed. A lot of folks may be surprised to learn that prior to those changes, unless you fit under a statutory exception, you could not carry concealed. In fact, up until I believe it was 1974, even a law enforcement officer could not carry concealed when off duty. That was a change that took place. I think it was 1974 or thereabouts. As we get started, we're really going to be focusing a lot on KRS 503. It has its title, which is the fancy title of General Principles of Justification, but nobody actually calls it that. It's just the use of force statutes. When we're using the word defendant, that's you. Don't get scared of that word. It just means that you're going to be in a position of defending your actions. And all I want you to think of when you use that word is you are going to be able to explain your actions. I'm a firm believer that if you can explain it, we can defend it. If you can't explain why you did what you did, don't ask me. I wasn't there and I don't know why you did what you did. So be prepared to say, this is why I chose to take the action I took. With that, chances are we're going to be able to defend it. I've left it this way because we hear so much about the Castle Bill. As we go through here, you're going to see a lot of language that's in yellow. Those are the changes that were made in 2006 by what most people think of as the Castle Bill. It did not make really dramatic changes in Kentucky law, but a lot of folks focus on it. So I want you to be able to kind of differentiate between what was already the law and what changed in 2006. The one thing to keep in mind with the Castle Bill, and here's a nice technical legal term for you, they took existing state law and this separate body of law that was being shopped around to the states, and they smushed them together. Okay, that's the best way I can describe it. They just took two bodies of law and squished them together. And unfortunately, that left a little bit of a mess behind, as squishing often does. I'll touch on those where it's important, but most of the time it just makes for language that sometimes is a little difficult to understand. Before we get into that, though, we got to go around and pick up a little bit more information from other chapters. What we're going to pick up in KRS 503, which is definitions. If you're ever around lawyers, you'll know lawyers love definitions because we've got to know how a particular term you're using is officially defined, because I may be using it differently than you may be using it. And we've got to come to an agreement on what that definition means before we can really have a conversation. Starting off, some of the things that are going to be important are what is a deadly weapon and what is a dangerous instrument? What is a felony, a misdemeanor, or a violation? And what is a physical injury as opposed to a serious physical injury? Because these are terms we're going to use. They're pretty common sense. Most importantly, in Kentucky, a deadly weapon is one of the items you see on this screen, which I'm going to go over. If it is not on this list, don't get creative. It's not a deadly weapon. It's going to be something else, but it's not a deadly weapon. First is a weapon of mass destruction, which I'm going to define separately in just a minute. Any weapon from which a shot that might hurt you or kill you can be discharged. Obviously, we're normally talking about a firearm there. A knife, other than the infamous ordinary pocket knife or hunting knife. Now, I dare say that most of the people listening to this have a pocket knife in your pocket. That does not necessarily make it a pocket knife. A pocket knife is normally defined as something with a blade of less than 4 inches, not the overall knife, but the blade, less than 4 inches that folds. If it doesn't do both of those, it's probably not going to be considered an ordinary pocket knife in Kentucky. A hunting knife, however, can be any number of different types of fixed blade knives. There really isn't a good, clear definition. The tolerance for knives really depends upon where you are. In some parts of Kentucky, when people get dressed, mostly males, but sometimes females, one of the items that you attach to your belt is a knife of some kind. That's just what everybody carries. No big deal. A billy, nightstick, or club. They do not specifically talk about what are now used, what are called expandable batons or ASPs. ASP is a brand name, but they're going to generally fit under this as well. Billies are shorter. A nightstick is one of the big long sticks that you see officers carry. A club can be any number of different things, but anything that isn't definitively created for something else is probably going to be a club. Blackjacks or slapjacks, don't see those too often, but I do know a few officers that have one tucked away just in case. What are usually just referred to as nunchucks, karate sticks. They can be any number of different forms, from very fancy ones that are made for folks who train in it, and other ones that are not so fancy. The only advantage of those is the individuals carrying them usually will hit themselves upside the back of the head before they hit somebody else. Shurikens or Death Stars, you've probably seen those. Sometimes they're called throwing stars. Or artificial knuckles, usually just referred to as brass knuckles, although quite honestly, they're very rarely ever made of brass. I've seen them made of ivory. I've seen them made of steel. I've seen them made of aluminum. They can be made of any number of different things. And again, if it's not on this list, it is not a deadly weapon. So you don't want to call something that's not on this list a deadly weapon. It's going to be something else. Weapon of mass destruction, as I said, was going to be defined separately. This was a definition that was added after 9/11. Pretty common sense. Any destructive device that's defined in KRS 37. Basically, if it blows up and it's not a firework under the law, it's going to be a destructive device. A weapon of mass destruction, toxic and poisonous chemicals, or what is used to create those toxic or poisonous chemicals. A weapon involving a disease organism, so it would be weaponized anthrax, for example. And any weapon that's designed to release radiation or radioactivity at a high enough level to present a hazard to you. That's pretty common sense, and that's pretty much in line with the federal definition as well. And again, if it's not on this list, it's not a weapon of mass destruction. What's the difference between a deadly weapon and a dangerous instrument? It's real simple. If it's a deadly weapon, it's on that list. A dangerous instrument can be anything that can be used to directly hurt you. We had a judge that had a geode. If anybody remembers what a geode is, those big rocks that if you break them open, they have pretty crystals inside. It was pretty good size. It was about the size of a softball, and his son had given it to him. It was broken apart to use as a paperweight. And they had a suspect who was standing in front of the judge. The judge had it on his bench as a paperweight, and he grabbed the rock and hit somebody with it. Well, that did not make the rock, which was a pretty substantial piece of rock, a deadly weapon. It made it a dangerous instrument. So it's always, pretty much anything you could pick up and hurt somebody with is a dangerous instrument. You just have to be, as part of that, explain what you did with it. So if I've got a baseball bat and I'm just carrying the baseball bat as you would normally carry a baseball bat, it's a baseball bat. If I swing it at your head, it becomes a dangerous instrument. Okay, hopefully that makes sense to anybody. Anybody has a question on that? But just think, if it's not on the list, it's not a deadly weapon. If it's used aggressively against you, it becomes a dangerous instrument. And you're just going to have to say, this is what they did with this item. I used to say that, about the only thing that couldn't be a dangerous instrument is a marshmallow, until we actually had a situation where somebody was choked to death with a large size marshmallow that somebody tried to jam down their throat, which thereby caused them to suffocate, and they actually passed away from it. So you can pretty much find something to do with just about any item you might pick up. Felony, misdemeanor, violation. The classification just depends upon what's the potential for the punishment. A felony means you're going to theoretically spend more than a year in prison. Misdemeanor means you're a county prisoner. You can spend up to a year in jail. And a violation is, just think, ticket. Most violations are traffic related, but not all. There are some other criminal violations that are not traffic related. You're going to look at, again, what's the potential for punishment. That can differ from state to state too. Physical injury versus serious physical injury. It is absolutely impossible to give a definitive list of either one of these. A lot of it is common sense. A few years ago, they did add a long list, which you're going to see in a moment, of injuries to children that would classify as serious physical injuries. Most of this is common sense. If it hurts, maybe you got to get a couple stitches, maybe you broke a finger, you go to the ER, they set it, they push you out the door. That's probably a physical injury. If you got to spend some time in the hospital, if there's at least a risk of death, a risk that you're going to suffer some type of serious disfigurement, burns, substantial lacerations, you're going to lose the function of a bodily organ, like you're going to lose your spleen. Those are going to be serious physical injuries. Don't stress about whether one's the other. That's for the lawyers to argue about whether or not a particular injury is or is not a physical injury versus a serious physical injury. It will be important when you're using force, but they're going to give you the benefit of the doubt on that. They're not going to make you justify if somebody's beating you in the head with a baseball bat, whether or not you fear serious physical injury as a result. So don't stress too much. Again, I threw this up here just to show sometimes what they like to do. Most of this is common sense. I think anybody would look at this list and say, yes, this must be a serious physical injury if this occurs to a child. To be honest, I would consider it a serious physical injury if it occurs to an adult as well. There's more on that list. Again, you're welcome to read them, but there's a lot on there. 527 talks about firearms and weapons. Just want to touch on those briefly. Destructive device is the same thing we talked about before. It blows up and it's not a firework. A firearm, anything that shoots something with an explosive. There has to be a bang and something comes out. That makes it a firearm. Handguns are those weapons, those firearms that are designed to be fired with a single hand. That gets a little creative sometimes when you get folks with different kinds of firearms, but they look at what it was designed to do. We're not going to go through it in detail. I just wanted to touch on a couple things in this. A CCDW is no longer required to carry concealed in Kentucky. I think it's personally still important to have one for a variety of reasons if you're going to choose to carry, particularly a firearm but in Kentucky, that is going to also apply to knives and other items as well. And there are a lot of folks who get one just to be able to carry a knife that might otherwise be classified as a concealed weapon or a actual deadly weapon. Most important, it is critical to understand your rights. There was a specific law passed some years ago because a particular employer who does employ, I believe, one of the individuals on this list, this is General Electric, that passed a rule that said you could not bring a gun in your vehicle onto their property. And this law was actually passed in direct reaction to that says you cannot be prohibited from having a firearm properly secured in your vehicle on your employer's property. It does not, however, obviously apply to federal property because we can't control what happens on federal property. But this was specifically passed in reaction to that rule. You can carry in a business if you're the owner, et cetera, with permission. Carrying on school premises is restricted. And again, you can carry on school property. If by chance we find ourselves on school property, you need to secure your weapon. They did make a slight change about students, some of whom obviously were 18 and theoretically could have weapons. They made some changes on that. But if we're on school premises, unless you're a law enforcement officer, you're going to need to lock the weapon up in your car. Juveniles, again, laws relating to juveniles are going to be different. 237, which is another body of law about firearms. They don't make it easy here. It is important with respect to the CCDW program, which is what it relates to. We're not going to cover any details about if you want to get a permit and you're not sure how to go about it, we're more than glad to help you, but it's not going to get into too much detail on that. Does include a couple of provisions I want you to be aware of. There is a list of places you cannot carry, and even if you're carrying without a CCDW, that list still applies to you. Okay. Places like police station or sheriff's offices, jails, which again, not places we're likely to have to go into, but it is going to be important to be aware of the laws on that. Many of these places obviously will have metal detectors. Alcoholic beverage locations, restaurants are not a problem. Schools without consent would be an issue. Daycare, some of these folks don't have a problem with you carrying, other places do. Airports in the sterile, they usually call the sterile area, which is once you get past the detectors, weapons are going to be prohibited. And any place where you can't carry under federal law. Okay, more layers, and again, signage, most places will put that sign up, but they're not going to make any effort to enforce it, but they might. So just be aware of it. Okay. There's no criminal penalty. They can, however, boot you out the door for criminal trespassing. That would be the penalty for it. Post-secondary education facilities that here in Jefferson County would be the University of Louisville, Bellarmine, et cetera. There are some conflicts with respect to other types of government locations. I will fully admit that pretty much my entire later career at U of L, after CCDW came into play, I probably carried any number of times, and I've quite honestly still carried on the U of L campus, and they haven't said a word. So particular importance, you can carry a concealed weapon any place you can carry an unconcealed weapon. So just be aware of that. I'm a great fan of concealed because I believe in the element of surprise. Finally, we're going to get into the actual use of force part. Starting off, we're going to touch a little bit on use of force for law enforcement, but mostly we're going to talk about citizens. Most of the law related to law enforcement officers using force duplicates citizens, but they do have some specific things that apply only to law enforcement officers. We do have citizens arrest in Kentucky. I guarantee you the Jefferson County Jail hopes you never exercise that. They do occasionally get someone showing up on a citizen's arrest, but I would not advise it. Getting into the definitions, this is probably the most critical part of this. We use the term deadly physical force. That is force that common sense tells you is likely to seriously injure and potentially kill someone. Okay. So aiming a baseball bat at someone's head is deadly physical force. You may not kill them. You may not intend to kill them. You may not even intend to hurt them seriously, but reasonable people know that you might hurt or kill somebody by doing that. We're going to keep using that word, reasonable. Reasonable is just the touchstone in this situation. You may think, well, I couldn't possibly hurt somebody with that. That isn't what the court's going to look at. They're going to look at those 9 other people who are going to say, well, yeah, of course you could hurt somebody seriously if you hit them upside the head with a baseball bat. They're the standard. So be reasonable at all costs. Dwelling, this is in fact a slight change. And so I realize some of the yellow is not going to show up on these because there should be some yellow on this. For years, we talked about what was your dwelling under the law. They did add the provision that an attached porch, if it has a roof. So Bud and Holly, I'm thinking of your front porch. Your front porch does not have a roof. You cannot use deadly physical force against somebody standing on your porch because that porch is not part of your dwelling under the law. If you have a carport, or you have a side porch, or you have a back porch and it has a roof over it, that roof extends the house. It becomes part of the house. If it does not, it does not. If you have an attached garage, that attached garage is in fact part of your house. If it is not attached, it is not. It is a separate structure. It is a building, not a dwelling. Okay. Imminent, just transfer the word immediate. If I call you up and say, I'm coming to your house, I'll be there in an hour and I'm going to kick your butt, that's not imminent. If I pound on your door and you open up your inside door and there I am trying to get through your screen door, now it's imminent. Now it's immediate, and that's going to be important in the law. The idea being is if I call you for an hour away, you can leave. You can take other action to avoid the confrontation. You can't avoid the confrontation when they're right there in front of you. This does come up a lot in domestic violence cases. This is where some of this, that past pattern of repeated serious abuse language you see on the screen, that's the battered spouse syndrome concept that's buried in there. Physical force, any force, you grab somebody, you hold somebody, you punch somebody, you slap somebody, you kick somebody. Those are going to be physical force elements. It does include, excuse me, I think I'm getting a chat here. There we go. It does include confinement. So holding somebody, kidnapping, that comes up in some of the kidnapping and again, some of the spouse abuse cases, is that idea of confinement. You know, I didn't hurt them. Well, no, but you lock them in someplace. You confine them. That is using force against someone when you do that. For officers, when they handcuff somebody, when they secure them in a car, that is physical force. And again, don't be afraid of the word, because what I'm going to ask you next is, why did you do it? Because that's what's going to be most important. Residents, temporarily or permanently, or visiting as an invited guest, that is a slight change in addition with the Castle Bill. If you go to someone's house and something happens there, you don't live there, it's not your dwelling, but you're probably going to react like if it's your mom's house for Sunday dinner, you're going to react if somebody kicks in her door, just like you would have reacted if somebody kicks in your own door. And the law was adjusted to accept that people were going to do that. As long as you're visiting as an invited guest, not a burglar, not a crasher, you're there as an invited guest. Vehicle, Any conveyance does not have to be motorized, which transports people or property. So in addition to vehicles and trucks, can involve horse-drawn vehicles, can involve bicycles, any number of things that would fit under that category. Justification. This is just a single sentence. You can see it on the screen, but it is so important. In use of force, justification is a defense. And just like I keep saying, we got to know what that means. What does it mean when I say something's a defense? A defense is going to be when you can say, yes, I did it, but. If you are involved in a use of force situation and you did it, yes, you shot someone, you hit someone, you ran over them with your car, you did something. You're not going to say, I didn't do it. You're going to say, yes, I did it, but I did it because. I hope that makes sense to everybody. If it doesn't, flag me. But that is such an important concept. You're not going to say, I didn't do it. You're going to say, yes, I did it, and this is why. Because that legal justification is that, and this is why. Okay, does that make sense to everybody? I'm not seeing any reaction emoji, so I think I'm good. You can even have a defense for doing something illegal, especially if it is to prevent a greater evil. We've had situations of people that have hurt people to keep them from jumping off a bridge. I had a friend of mine who, as a lady was getting ready to jump off the Sherman Benton Bridge, he basically reached out, and unfortunately what he managed to grab hold of was her hair, because she had long hair, and he pulled her back by her hair, and obviously he hurt her. You know, he accepted he was going to hurt her by doing this. That was justified because he was trying to prevent something greater. The only thing that you cannot argue under what is called choice of evils is an intentional homicide. You cannot shoot one person to keep somebody else from being shot. We can justify it under something else, but it won't be justified under choice of evils. You will, again, I've seen, we did have a deputy that dislocated a lady's arm. She was getting ready to jump from the 3rd floor of the Hall of Justice down into, if anybody's been in the original Hall of Justice, it's a three-story drop down into the atrium. He dislocated her arm pretty badly. Knew he was probably going to do it by the way he had to grab her. But the difference was either she was going to fall to her death, or even more likely, she was going to fall, land on somebody else and cause harm to them. So it was justifiable for that reason. Getting into the meat of this, you may use physical force to protect yourself when somebody else is using a similar amount of force against you. That's pretty common sense. I punch you, you punch me back. Most people understand that concept. It's not too much of a difficult concept. You may use deadly physical force, and that can include shooting, stabbing, running over somebody with a car. I mean, whatever. Again, force is not tied to what you are using. Force is tied to the action. If you believe this is what I have to do to protect myself, because we're talking about self-defense right now, against death, serious physical injury, kidnapping, or forced sexual intercourse. In Kentucky, that would be rape or sodomy. Okay. You can use deadly physical force to protect yourself in these 4 instances. Now, they've added something else we're going to talk about in just a second, but these are the big 4, and this is what's been in Kentucky law for many, 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 many years. And they make sense. They make sense. They used to say with kidnapping, oh, no problem. Some of you may remember the original incident, or the book written on it, which is called The Onion Field, which involved kidnappings of officers in Los Angeles. And the officers were actually told, oh, just go along with them. They'll let you out on the other side of town. You'll be fine. That worked fine until that isn't what happened. And one of the officers was murdered. The other officer escaped, but suffered from what is called survivor's guilt for the rest of his life for not protecting his buddy. They did add felony involving the use of force. I will argue that pretty much anything that falls under this will also fall under one of these four. So they added it. I don't really feel like it was really necessary, but they did. It's broad language. You know, there's any number of crimes that could fall under this. Robbery, if somebody's robbing me, I'm going to assume they're willing to hurt me. So again, we don't really think it's going to make a big difference. This is the battered spouse defense. I wanted to leave this in here because prior acts of domestic violence or abuse can be admitted to explain a subject's use of force at a later time. For example, someone who has been physically assaulted, they wait till their attacker goes to sleep and then they take action against them. This is what this falls under. You do not have a duty to retreat. You probably heard this any number of times. We laugh about it because that's actually been the law in Kentucky for a very long time, that there was no duty to retreat. There's a good quote on that regard that from, I think it was about the 1950s, where the judge said something like, "We are Kentuckians, we do not run." So it's been the law that we've not had a duty to retreat, but they put it in the law. Defensive force, this is an all new statute that came in as a result of the Castle Bill. It is a presumption of fear. You don't necessarily have to prove that you're afraid. We will believe you are afraid under certain circumstances. This is somewhat awkward language, but what we're mainly talking about is if somebody forces their way into your house, your dwelling, or your residence, and there's a slight legal difference between the two, or your occupied vehicle. That's a carjacking. Somebody that tries to get into your car while you are still in it and take off with it is a carjacking. Somebody who grabs you and pulls you out of the car and takes your car is a carjacking. Legally in Kentucky, we don't actually ever charge with carjacking. The feds do, but we don't. If they pull you out of the car, throw you to the ground and take off with your car, that is a robbery. If they push you to the other side of the car, jump in the car and take off with you in it, it is a kidnapping and a robbery. So that's the legal terms we'll use in Kentucky. But in neither one of those situations, we're going to presume you are afraid and you are allowed to take appropriate action there too. We will presume that you knew that it was going on. We don't really know what that means. We've always laughed about that sentence. The presumption, you have a right, presumes that you have a right to be there, and there's not some type of, say, an EPO or DVO that would keep you out of there. It only applies if you have a right to be there to begin with. Somebody's trying to take your child or grandchild. If the person who's using defensive force is engaged in an unlawful activity, we're going to say the presumption doesn't apply. So these are unusual situations, so we don't spend a lot of time on them. This mainly applies to law enforcement officers who enter in the performance of their duties and properly identify themselves, are presumed to be allowed to enter. Even if you don't want them there, you let them in and then you deal with it later in the courts. This is the only place you're going to see the stand your ground language in Kentucky. A lot of cases, they use the term stand your ground, but rarely is it an actual true stand your ground case. Stand your ground means that you are allowed where you are allowed to be, and you are not required to retreat, and you may return force with force if appropriate. So if you're in your living room and somebody breaks in, you're standing your ground. But most of the cases called stand your ground cases are really not under Kentucky law anyway. If they come in your house, we're going to presume they mean to do bad things to you. Okay, it's a legal presumption. You don't have to defend. You don't have to say I was afraid. All you got to say is they had no right to be there. As such, there's no duty to retreat. There's the quote that I mentioned, a Kentuckian never runs, he does not have to. And again, we will presume they have bad intent towards you. Improper use of physical force. It's very, very fact specific. The relevant provision in this for you guys involves provocation. You don't get to provoke somebody into physical violence and then use physical violence against them. It's a kind of a back and forth. So just don't provoke, respond, but you don't provoke. Protection of another. This is a separate piece. You may use physical force to protect someone else if you can kind of put yourself in their shoes, and you could have used physical force if it was happening to you. So if you see someone attacking another person and you go up, are able to apprehend them, subdue them, you can use the same amount of force as the person that they were attacking. Again, most of the time when that happens, they're going to turn on you. You're now going to be protecting yourself under self-defense. So it can get a little complicated from a law enforcement standpoint. From a law enforcement standpoint, we're usually looking at things like SWAT shootings, where the individual who's taking the deadly force action isn't at risk. You know, they're up on a high building with a scope and they're shooting somebody on the ground that doesn't even know they're there. It gets complicated when you're getting deadly physical force mixed in, but it's a separate body of law. Bud's asking, what if they can't self-defend? That's what it's intended to protect. If they're on the ground, they can't protect themselves. You always kind of imagine you're putting yourself in their shoes. You're protecting them because they can't defend themselves. Okay. Again, the court's going to give you quite a bit of slack on that. We've had some complicated cases with law enforcement on that. Some of the back shooting situations, SWAT shooting situations sometimes fall under this. Circumstances as they believe you believe them to be. If that's for physical force, if you're using deadly physical force, same four categories, but here's a little complicating factor. The circumstances as they actually exist. And that's where, again, most of the cases are going to be law enforcement, but you could have a citizen situation where you see someone that looks like they're pointing a gun at someone else. You pull out your handy revolver and shoot them, only to find out that they were pointing a fake gun at someone else. So the circumstances as they actually were was that third party was not at risk. So it's just take your time, assess what you've got, take that extra minute to take a breather before you take action. Again, most of the time, the grand jury is probably going to work with you on that, but you'd rather not be in that situation. And again, I've seen a few cases, one that could have gone very, very bad, except for the officer taking the time. Some of you might have remembered, it was an incident. This is actually a good example. The Kinko's downtown, in the middle of the night, some of the employees decided to stage a fake gun battle in the Kinko's with what appeared to be real long guns. This was before they put the orange tip on water guns and such. And they looked real. And an officer driving by on Market Street in the middle of the night thought that there was an armed robbery going on in the Kinko's. Fortunately, he basically held it, called in for assistance. Somebody got the bright idea, before we do anything else, let's just call the Kinko's. At which point the guy with the fake gun put it down, answered the phone. Hello, this is Kinko's. How can we help you? This is the Louisville Police Department. We suggest everybody in there come out with their hands up. And again, nobody got hurt, but that could have gone real bad, real fast, had the officer taken action under this statute. There's that no duty to retreat again. They really like that language. Protection of property. I hate that they say protection of property on this. I wish they'd called it, this title at the top had been something else, because it can be very deceptive. You may use physical force if you believe it is necessary to protect property. Note, physical force. Somebody runs into your yard, picks up your garden gnome out of your garden and runs off with it. You can chase them down and wrestle them to get your garden gnome back. That's okay. That is physical force. You may not shoot them over your garden gnome. No matter how much you love your garden gnome, it's property and nobody dies over property. Deadly physical force, which is discussed under this, gets a little more complicated. Physical force for property, deadly physical force, while it might be tied to property, is only used because there's a physical risk. This is the ones when we talk about, can I shoot somebody who is in my house committing a burglary? The answer is yes. Not because we care about your television getting stolen, but we care about the fact that if someone enters your house, they put you and your family at risk. Okay, that makes sense to everybody. I'm not getting any reaction, so I'm hoping it does. Robbery and one of our pet peeves, burglary and robbery. Burglary is somebody entering your home where it can be your business too, it can be a building without permission with the intent to commit another crime. Most of the time that other crime is theft, but we will charge with burglary. In fact, one of the primary burglary cases where this was a factor is a guy who's currently on death row because he used a weapon to shoot the lock off of a door, entered the building, there's the burglary, and he did that with the intent to kill the occupant. So that's the crime that he committed when he got inside. So the burglary was an aggravating offense to the murder that he committed. But burglary is coming into a place where somebody does not belong, residence, building, dwelling. There's different categories for what the actual the building is, but that's what burglary is. Robbery is up close and personal. We say burglary is a crime of property. Robbery is a crime of person. Robbery is me using force to take something from you or to try to take something from you. The best ones are where they are unsuccessful and they still find out they're charged with robbery, even though they didn't get anything, because it does not require that they be successful. It can be an armed robbery. They use a gun or a knife. It can be what is called a strong arm robbery, where they're just using the threat of force against somebody. Even a purse theft, a purse snatching off somebody. The lady's got her purse over her arm. Somebody comes up, grabs it, pulls it away from them and runs off. That's a robbery. It's also a theft, but it's a robbery. A felony involving a use of force or other circumstances which were covered under 055, but they're so rare. This is where dwelling and residence come into play. Dwelling, you live there. That's the only difference. Dwelling and residence, you live there, as opposed to robbing, the grocery store. That's a different type of situation. Committing arson, it gets a little interesting to folks. Somebody who is committing or attempting to commit arson of your dwelling or any other building in your possession. You may use deadly physical force under those circumstances. If they're burning down the shed in your backyard, I would prefer, number one, you call 911 and get the fire department there and not shoot them. But because it's never, ever a light matter to take somebody's life. But in my case, my garage is right next door to my house. I mean, if somebody catches my garage on fire while it is technically a detached garage, it is so physically close to my house, and in fact is connected with an overhang, that catching my garage on fire would likely catch my house on fire as well. So they look at those type of a situation. I would probably be justified. But again, and this is something I always go back to, rather than worried about doing that, I'd be more worried about calling 911 and getting both the police department and the fire department there to put the fire out. So don't lose track of the goal, which is keeping the house from burning down. But arson is an interesting category on that, because it is a property crime, but it can also obviously be a fatal personal crime as well. No duty to retreat. In reality, we just don't think the Castle bill added that much to the mix. A lot of language here. We're going to look at a situation, and this comes up with some of the new cases. If someone takes action that is at least arguably good self-defense, then there are protections. This is something new in the Castle bill. They should not arrest you. And this gets a little problematical. One of the very, very first cases right after this bill came into play was a situation at 2nd and Liberty. Some of you may know that intersection at the time, and still is. It's kind of the bar corner. Right there is where Hurricane O'Malley's and Coyotes and all that were. There was 2 young men who had been arguing. One took off after the other. They were both in their vehicles. They stopped at that intersection. One of the young men hopped out of his car, ran over to the other car. The passenger side window was down. He was basically trying to get in through the passenger side window, trying to get to the driver. So he was coming across the passenger. The driver shot and killed him and kind of pushed him out of the car at that point, and then drove several blocks away, at which point he called 911. Because that individual was effectively trying to, at least arguably, commit a carjacking. He wasn't trying to steal the car, but he probably was trying to hurt the driver. That was held to be justified under the Castle bill, and he could not be prosecuted. A case that occurred a while before the Castle bill came into play is a good way to contrast it. Real life story. I would change the names to protect the individuals involved, but this is one I'm very familiar with. Gentleman, we'll call him Bob, was visiting his girlfriend Sally. He does not live with her. They are sitting on the couch eating popcorn when somebody puts a size 13 through the front door of her house. Kick the door in. Bob picks up his weapon. He is a lawful concealed carry. This was right after the CCW law came into play. He picked up his weapon and he shot and killed the person who was coming into the house. Note, he did not live there, and this was before the law covering invited guests kicked into play. Turned out it was his girlfriend's ex-husband who was mad about something completely unrelated to Bob being at the house. He was making threats toward her as he was coming in the door. That's why he got shot. The person who shot him was locked up that night. I mean, he was arrested at the scene and booked for killing this individual. Absolutely nobody disbelieved what had actually occurred. Everybody believed that that's what I just recited was exactly what occurred, but they locked him up that night. He was bailed out before the end of the weekend. This was a weekend. He was charged with murder. Don't really know who thought that was a good idea. He invoked speedy trial and went to trial 72 days after the shooting. And the jury was out about 5 minutes and basically wanted to know why they were there. He was acquitted promptly and everything was good. Had that happened now, he could have sued the department for locking him up that night, because under this law, he had a good arguable defense to why he did it. He wasn't going to run. They knew who he was. He was a librarian. I do not lie. He was a university librarian. And as a result, he was out $50,000 into defense fees for something he never should have been locked up for to begin with. So that's real story. Anybody wants to ask me later, I'll tell you what his real name is. Law enforcement agencies should have laws on this. You get reasonable attorney's fees as well as damages if this occurs to you. This is pretty common sense. There is things that the law enforcement's allowed to do. They can certainly investigate it. The biggest thing is they cannot lock you up until they have shown that your self-defense or your defense justification will fail. Up until then, they got to leave you alone. And I think that's the way the law should be, personally. Touch upon this because we do see this. A lot of people talk about, is spanking legal? The answer is yes. You may use force for care, discipline, or safety. Remember what I've said about force. Force is not necessarily being mean to somebody. Bud, deals with individuals who sometimes may have to be confined and held for their own safety and the safety of someone else. It doesn't mean you're being mean. You're not trying to hurt anybody, but you might have to confine in some way. That's force. And as a result, it falls under that. I had a friend who had a mother who, if she could get out the door, she'd be out on the railroad tracks. So they had to keep her locked up. She was never alone, never at any risk being locked up, but she had to be kept locked up. And every once in a while, she'd get the phone and call 911, and the police would show up and everything would be okay after the situation was explained. All right, it's a lot of info. So everybody's brain's probably about to explode. Does that make sense to anybody? Does it make any questions? If you want to unmute if you have a question, or you can put it on the chat, whichever you prefer. Not getting anybody. Bud, you want to unmute? I hope Bud didn't play the mixtape during all of that. Anybody got any questions? And again, if you have a question later on, please feel free to pop it to me. Again, every situation's different. I'll just go back and reiterate one more time. The big thing is, if you have to take action, tell the truth and explain why you did it, because that's what's so critically important. The law is pretty protective. I personally think we got a pretty good law. It could have been a little better squished together when they merged the two bodies of statutes, which left some awkward situations. I will touch on, there's one thing we don't talk about in this. Law enforcement does have a separate law that applies to them with respect to using physical force to make an arrest and using deadly physical force in situations where the general public would not be allowed to do deadly physical force. I do want to just mention it just briefly, because it does come up in a couple of cases. And one example, and this example I think will explain it. Quite some years back, an officer was called to a scene of a shooting. When he arrived, several individuals were on the ground. He knew at least one of those individuals was deceased. So he knows he's got at least a homicide at this point. One of the individuals there kind of did the proverbial, he went that way. So the officer went in the direction, he's calling it in, all the things officers would do. He's calling it in, telling his fellow officers where he's going. He catches sight of an individual running from the scene, and he's beating feet down the street. The officer yells at him, "Stop, police." The guy doesn't stop. That's actually not unusual. If I'm running away from a shooting, even if I didn't do it, I'm probably not going to stop. He realizes the subject who's running away has a handgun. He's carrying the gun as he's running. The officer sees this. Again, still could be somebody running after the shooter, could be a plainclothes officer. Doesn't know at this point. At some point, and they're roughly 80 feet apart at this point, the individual in front turns, points at the officer, fires his weapon, shoots the officer in the upper right arm, then turns and continues to run. So now his back is presented to the officer again. The officer manages to, he had actually already drawn his weapon, so he had his weapon in his right hand, take his weapon from his right hand to his left hand, steadies himself, and shoots the guy square in the back, and drops him. He is, referring proper terms, DRT. He's pretty much dead right there, because the officer hit him square between the shoulder blades. Phenomenal shot, given the fact he's already been shot in the right arm, and he's at that point roughly, I think it was 92 feet apart. He shot him in the back. Under Kentucky law and the law of most states, that is a justified shooting because it meets certain criteria. The individual was involved in a serious felony for which he would have been arrested and which was causing potential harm to all sorts of other people. It turned out the individual was a paid assassin who was paid to assassinate one of the individuals at that corner. So really wasn't much that was said as a result of it. but it was a back shooting, and that, you know, and it was a perfectly legally justified back shooting under the circumstances as occurred. Even if the officer had not been hit, if the guy just fired at him but not hit him, and then turned and continued to run, it still would have been a legally justified back shooting. But that falls under law enforcement statutes, not the general citizen statutes. Okay, that makes sense to everybody? Again, I'm not, comments, questions? All right, Bud, I'm going to turn it back over to you.
Okay, I think I'm unmuted. Am I unmuted?
Yeah, nope, you're unmuted at the moment.
What about the use of pepper spray, Shawn? Any?
Pepper spray is not deadly force. There the few situations, and there's been very few that they've actually had to deal with it, they've classified it as physical force. So if physical force is justified, then your force would be justified as well. So again, there's not been a whole lot of litigation regarding pepper spray, but I would feel comfortable arguing it as physical force. There's been some talk about disarming officers with respect to tasers, and most courts, except for one state that wants to do something completely different, tasers and pepper spray are classified not as deadly weapons, and they shouldn't be deadly weapons. That's not what they're for. So they would be classified in a different level of force, which would be physical force. It's going to hurt like the dickens. Anybody here ever been shot by a taser or felt a taser? I mean, it hurts. But then you get up, shake it off, and you're okay. And that's the whole point of a taser. We don't want them to be classified as deadly physical force. And so far, with the exception of one oddball state, they're not being classified that way.
Two more things, Shawn. What about if someone occupying a abandoned house, do they have any rights to do harm when someone's coming in to search that house?
Legally, the answer is no. They are not an invited guest, and they are not a resident. It gets complicated when you're dealing with those situations, and they should be treated as a trespasser. But again, just being a trespasser in a separate house is not going to be enough for deadly force. If you're coming into the empty house, it's not your house, you're not defending your house, you wouldn't be looking at deadly force. That's where physical force would be, unless, again, these things can turn in a heartbeat. And we have had an officer shoot someone in an abandoned house. One of them was actually an accidental shooting. They didn't intend to shoot the other. The other was the individual was in the house, but then they charged the officer. That changed the situation. They're no longer a trespasser. Now they're an attacker. And so that's why these things are so fluid. They change. You got to sit and get all those facts out on the table.
Okay.
What else?
The only other one is make sure everybody knows this is a 2-part class. Daryl, I think we have Stop the Bleed on Tuesday. If you haven't had the hands-on part, I see a lot of people in the class now who hasn't had the hands-on part. When you do the hands-on part, then we'll get a certificate to you. But if you had the hands-on, we'll use your Cubiton or your flashlight to defend yourself. And this class, then you'll get a certificate. And that's all I have.
Anybody else got any questions? And again, if you think of something, please feel free to ask. One day we're going to have a class. I'll bring my bag of deadly force stuff in my, I've got a big bag full of all sorts of items that we use in class, in terms of what's deadly force and what's a deadly weapon and what's a potential dangerous instrument. So I've got a huge bag full of stuff I carry for that. With Laura's asking about your dogs. They're going to look at it in terms of property, but here's how I would argue. If I had to argue it, you're going to go in to physically protect your dog. I mean, Laura's asking the question, so I'm going to use Racer as an example. He's a small dog. He's a tough little guy, but he's going to need help to protect himself. Once you get in there to engage to protect him against, if we're going to presume this is a human causing harm to him, they're going to turn on you. At that point, it's self-defense. And I'm going to argue that as soon as that person takes the attention off the dog and turns towards you, which they're going to do if you're intervening, now I'm going to argue it under self-defense, because then it's going to be clean. And I don't know any court that's going to have a problem with that in Kentucky, because they're going to expect you to intervene to protect your animal. What you really want is a judge and a lot of jurors with pets. And you'll be in good shape. If we've got an individual who's running for county attorney, I don't know, some of you may have seen this. He's going to be a great advocate, because should he win, and I think he probably has a good chance of winning, because not only does he have a pet dog, he also has a assistance animal. He actually he has a guide dog. The individual's blind, so he has both a pet dog and an assistance dog. The pet, by the way, is his prior assistance dog, who no longer can serve as a seeing eye dog.
Is that David Holt?
Yeah, it's Holton.
Oh, okay. I served on a couple committees with him.
Yes, Holton has announced that he's going to run for county attorney.
So maybe something else before.
I have.
Your phone number.
I don't think I have one for you guys, but I don't.
And yes, but to take, but you also have abusing or killing a service animal. Yes, that would fall into there as well. Because and again, they're gonna cut you slack on that. They're gonna cut you slack on that, because it's gonna be instinctive to protect your animal. That's just be it your horse, be it your cat, be it your dog, be it your ferret. It's going to be instinctive for people to do that, and I just don't think any court's going to really have a problem with that. But again, as soon as they turn towards you, now all bets are off. Now it's self-defense.
Thank you,
Yes,
Shawn.
by the way, an animal can be a dangerous instrument. If somebody sicks their dog on you, the dog has become a dangerous instrument. Yep, Drake could be dangerous. All right, comments, questions? Bud's still got his hand up.
Oh, I don't know how to lower it.
Pam's clapping over here. I can see all the emoji. I've got it pretty well set up on my screen here now. So,
Oh.
So everybody good?
I'm good. Thank you, Shawn.
That's right. I think that this worked out pretty well.
Yeah, good. Yeah.
Yeah.
Right. Cindy, were you in the hands-on class 2 weeks ago?
Yeah, she was.
Okay, that's what I thought. I'm doing certificates now, and I forgot if she was on there or not.
Yep.
Thank you so much. You too.
All right. Well, Holly, you're controlling the meeting, or Shawn controlling the meeting?
I've turned my screen over to you guys, so I think you're
Okay,
back.
you have control, Holly.
She has
Later, guys.
control. All righty. I think I can end meeting if you want me to. I think I can. It's given me the option anyway.
Yeah, go ahead, Shawn.